Kia ora koutou katoa. Greetings to our university and law school family, and ngā mihi nui to our friends joining us virtually from our law, government and other surrounding communities. For those that don't know me, my name is Dean Knight and I'm a member of the New Zealand Centre of Public Law and Faculty of Law at Te Hinganawaka, Victoria University, Wellington. And it's my pleasure today to be introducing our speaker, the Honourable David Parker, Attorney General. And can I start by saying that accountability matters, especially so during times of emergency where extraordinary powers are wielded by government. And the first act of accountability is a rendering of account by government actors, explaining their theory of the need for action and explaining why they believe their use of power, extraordinary power, is justified and fairly deployed. Thus, the New Zealand Centre for Public Law is delighted to host our Attorney General to hear an explanation and justification of the measures deployed by the government in the fight against COVID, especially an explanation of the new COVID protection framework, the so-called traffic lights. And we all know that the Attorney General serves an important guardian of rights in the policy and lawmaking process, and we'll be interested to hear how the government has grappled with those important questions when battling the virus. Some of us remember well the Facebook Live during the lockdown last year, where our guest addressed us on the then live debate about the legal underpinnings of the lockdown, and we very much welcome the tradition of direct engagement by the attorney with the legal community on these matters of real constitutional moment. And we also do appreciate the attorney's willingness to speak candidly with law students about the work he does. And we remember a rich conversation with students in our COVID-19 in the law class last year. Finally, accountability is also an exercise in dialogue. Forums, including the one assembled today, have the opportunity to interrogate the explanation rendered, testing and ultimately passing judgment on the exercises of power under scrutiny. Now, some of us here today have already taken the liberty of engaging in that dialogue, raising eyebrows about aspects of the recent lawmaking process, but I think today provides a welcome opportunity to continue that dialogue in a more conversational setting. Following the attorney's remarks of about 35 minutes, there'll be an opportunity for questions from our forum. First from those assembled in the room here, and secondly from those joining us virtually. For virtual participants, the Director of the Centre for Public Law, Professor Joel Colden-Rios, will be your voice. If you can type any questions in the chat or Q&A function on Zoom, he will ask selected questions on your behalf. So with that, can you please join me in welcoming the Honourable David Parker, Attorney General of New Zealand, to address us on the legal and constitutional implications of New Zealand's fight against COVID-19.
Tēnā koutou katoa. Thank you for those introductory remarks. Thanks for all turning out today. Some weeks ago, knowing that the end of the year was approaching and that the change to the traffic light system was coming, I approached the faculty to see if we could host this here. And I really am pleased to have the opportunity to talk about the constitutional consequences of COVID-19. I'll just get my little clip out. Here we go. I've got a great love of the law, so do a lot of other people here. The way it exists with the consent of the people for the benefit of the people. And the COVID crisis reminds us of this. I'm going to leave this slide up for most of this address because it shows us that we've had the best result among OECD countries in terms of low mortality, including among other island nations such as Iceland and Ireland, proving that the success that we've had in New Zealand isn't just about the moat around us. And the law has been an essential ingredient to the outcome so vividly shown here. We're the bottom country on this graph, and it equally could be about hospitalisations or infection rates, not just about death. When the virus first appeared in our communities, the Prime Minister has said there was no rule book and much was unknown. But seeing the spread and the mayhem overseas, fundamental strategic decisions had to be made. We determined that a public health response informed by science and medicine would be our best way forward, focused on saving lives and livelihoods. And this strategy has guided us throughout. The potential for societal and economic disruption was palpable. It was obvious that the existing legal framework needed to be updated. High rates of voluntary adherence to restrictions were needed, which relied upon public confidence. Unity, the team of 5 million, was the basic building block to maintain confidence, which in turn required compliance with the law, legal compulsions that impact civil liberties. More often than not, we've been requiring the unwilling to do what the many were or would do of their own volition. Social distancing, checking in, mask wearing, testing, vaccination, lockdowns, closed borders and MIQ have enormously disrupted going about our daily lives. The sacrifice has been burdensome, but that we, together, have achieved a world-class response is tribute to the tenacity of our people and the strength of our community. The loss of liberties caused by COVID has brought into play very important Bill of Rights issues, and I want to focus on how we've sought to address them, and we'll cover the checks and balances that we've adopted, including the many mechanisms that we have embedded to maintain the ability of Parliament and the courts to scrutinise and, if appropriate, curb the exercise of executive powers. I've greatly appreciated the thoughtful and helpful critiques and suggestions provided by legal academics from this and other law schools, many of which have been adopted. I'll reflect on the effect of the Delta variant and then consider what our lives look like now that vaccinations are available and the rate of uptake is high. As we transition from border protections to vaccine protections where we each carry our share, it's easy for critics to glibly take for granted how effective New Zealand's response to the global pandemic has been. It has been world-leading, and it's pleasing to see how the low death rate, economic resilience, and more freedoms relative to many other countries has been acknowledged in recent court decisions on challenges to aspects of the framework. Had we not broken the chain of transmission, the exponential growth seen overseas would have occurred here. Back then, testing and contact tracing were constrained for a number of reasons, including the worldwide shortage of test kits and PCR test reagents. The situation evolved rapidly. What we knew about the virus, its spread, and the gravity that we faced was changing every day. It's our social cohesion that has allowed us to successfully battle the pandemic. The clear and early communication of risks and requirements by health experts, the Prime Minister and other ministers was a key ingredient. We adopted public health measures such as physical distancing, washing your hands, staying in your bubble. We were one of the first to roll out our support to those impacted by the pandemic, cushioning the financial and economic blow for New Zealanders. It was the right thing to do, but it was also necessary to maintain the social contract as we pulled together to tackle the public health emergency. That wage subsidy kept workers attached to their workplaces and supported demand in the economy. At its peak, it supported 2/3 of the labour force and had the broadest reach in the OECD. Social support benefits were increased by $25 too. Our Go Hard, Go Early approach in 2020 was both the best health and economic response, evidenced by low unemployment, lower deficits than forecast, and credit upgrades from international agencies. Through all of this, we have not lost sight of the importance of civil liberties. The importance that I and the government attach to civil liberties has been demonstrated by many active steps. The repeal of the repugnant 3 strikes legislation, the repeal of arbitrary restrictions on prisoner voting rights are both specific instances. The progression of the so-called halfway house under the Bill of Rights Act, creating a pathway for a considered and often less politicised response by both Parliament and the Executive to declarations of inconsistency by the higher of the courts. This will be of enduring effect, and it's been described by Sir Geoffrey Palmer, who's here today, as perhaps the most important advance for the protection of civil liberties since his Act was passed in 1990. It's with that high regard for civil liberties that we've taken decisions about how we use the far-reaching powers under pandemic legislation needed to limit the havoc caused by a deadly mutating virus. The restrictions imposed under Section 70 of the Health Act to facilitate the first lockdown were far-reaching, and as you'll be aware, were subsequently challenged in Borrowdale and the Director General of Health. A full bench of the High Court rejected the challenge to the orders and found that the Director General was entitled to exercise the powers. The court also held that while the requirement for the New Zealanders to stay at home for the first 9 days of the lockdown was justified, it was nonetheless unlawful. It found that for those first 9 days, the limitation on the rights protected by the Bill of Rights Act 1990 wasn't correctly authorised until a further order was made under the Health Act. The decision of the High Court in Borrowdale was upheld in the Court of Appeal, and as that court observed, the powers under Section 70 of the Health Act were, quotes, intended to facilitate an immediate and urgent response to a public health crisis. The Health Act, which in many ways is predicated on quarantining, did not provide the framework needed for a longer-term response to COVID. Bespoke legislation was needed. At the time, it was all hands to the pump. And unusually, Cabinet handed me, as Attorney General, responsibility for urgently developing the legislation, utilising leading lawyers from across government, including Crown Law, MB, PCO and DPMC. The bill was introduced on the 12th of May and went through all parliamentary processes under urgency, receiving royal assent on the 13th of May. As Justice Cook summarised it, that Act established powers to make orders with restrictive effect to address the risks of an outbreak and further spread of the virus. From my perspective, the COVID-19 Health Response Act 2020 incorporated a number of very important safeguards. It made ministers, rather than the Director General of Health, responsible for the main orders under it. It requires the minister to be satisfied that each order is justified under the Bill of Rights. It limited the powers under the Act to the COVID pandemic. The Act self-repeals every 90 days unless Parliament passes a resolution for it to continue. Orders under it are revoked unless Parliament approves within each order within generally 60 days. The Act puts orders under it within the purview of the Regulations Review Select Committee, which is chaired by an opposition spokesperson or an opposition member, and their recommendations have resulted in improvements to subsequent orders. The Act expressly preserved the role of the courts to judge orders against the Bill of Rights Act 1990 and requires orders to minimise intrusions into civil liberties. We even went to the extent of appointing the Minister of Justice as Acting Attorney General for the purposes of the Bill of Rights vet on the bill because of my conflict arising from my policy responsibility for that bill. Although the Act was necessary and properly passed under urgency, we adopted a number of suggestions from legal experts and the opposition, including to immediately put the Act to a select committee for scrutiny via its inquiry function. While Parliament wasn't sitting, we also maintained a special select committee chaired by the Leader of the Opposition, which ranged transparently and widely. All COVID orders made subsequently and actions pursuant to them have benefited from both the checks and balances in the Act and the recourse of citizens to the courts. The COVID-19 Public Health Response Act has, I believe, served us well. And consequently, we enjoyed the summer and much of early 2021 with fewer restrictions, save some short, sharp lockdowns to stamp out the virus when it reappeared. Our freedom was in stark contrast to much of the rest of the world. The emergence of the Delta variant, however, radically changed things. It is more contagious, spreads faster, it's harder to contain than the original COVID strains. It can cause more people to develop serious illness with higher numbers in hospital. The strain on our health system of a substantial outbreak among an unvaccinated population could overwhelm it to the detriment not just of those with COVID, but also others who require medical treatment for other reasons. When Delta appeared in our community in August, we needed to act decisively. The country rapidly went into a lockdown again, and we revived supports like the wage subsidy. Once again, the community spirit required to stop the spread reignited nationwide. There can be no question that the recent lockdown in Auckland and neighbouring provinces has slowed down transmission and saved lives and livelihoods. This graph just amply shows it, and I'm very pleased that in recent weeks the number of daily infections has decreased compared with the rapid exponential growth in infections we would otherwise have seen. And this has also brought us time to transition from border protection to vaccine protection. Thanks to the tremendous work of scientists, extraordinary global cooperation, we now have a strong method of protecting ourselves, our whānau and our community from the worst ravages of COVID, including the Delta variant. Widespread uptake of the vaccine is fundamental for New Zealand's health and well-being. Its rollout here and overseas is central to our ability to ease restrictions and reconnect New Zealand with the rest of the world. And we're doing very, very well on this front. We have over 90% of the eligible population having had at least one dose and more than 85% double vaxxed. We're striving for over 90% to have 2 doses across the country. We set the vaccination challenge for New Zealand knowing that without high rates of vaccination, freedoms would need to be constrained to stop the pandemic spreading. Higher risks arise from and for unvaccinated people. Hard decisions have to be made about what life looks like for those who choose not to get vaccinated as we seek to maximise the freedoms and health outcomes. Government had to decide what levers should be able to be used consistent with fundamental rights and New Zealand's values. Many people will be familiar with the philosopher John Stuart Mill's harm principle. He said, "The only purpose for which power can be rightfully exercised over any member of a civilised community against their will is to prevent harm to others." The Bill of Rights Act is not prescriptive as to government conduct. Policy choices are available, provided that where protected rights are engaged, the outcomes remain justifiable under the Bill of Rights Act. The most obvious right engaged by the question of vaccines is Section 11 of the Bill of Rights Act. It protects the right to refuse to undergo medical treatment. And the Supreme Court considered Section 11 in New Health New Zealand Inc. against South Taranaki District Council. That was a fluoride case. And the Supreme Court took an expansive view of what it protects. We've had to, in government, grapple with questions about this, how the approach to this right applies and what limits to that right are justified in the COVID pandemic context. When does the state's legitimate interest in protecting the public justify consequences for individuals who remain unvaccinated? There have been a number of cases in recent weeks that have considered this. Important decisions by Justices Churchman, Cook and Palmer have addressed the vaccine rules that we've imposed for border workers, customs, teachers and health workers. As Justice Cook noted, in recent times there has been a very strong emphasis on vaccination and the benefit of as many New Zealanders as possible being vaccinated for the overall public good. It is a matter of observation that in public discourse, those who are not in favour of vaccination can be subject to criticism and at times public condemnation. Within that environment, the court plays an important role. A fundamental right in the Bill of Rights is being limited. He noted that the applicants explained why they did not want to be vaccinated and that they had lost their employment as a consequence of the measures. He also noted that they have been frontline in the public health response to COVID-19 and that they had described the difficult circumstances they faced, including in isolation facilities, And he said, "They should not be thought of as any less committed to the community than any other New Zealander." I think I should emphasise that. These cases raise group versus individual rights. The pandemic and the availability of COVID vaccine highlights the tension between group interests and individual liberty interests, because other individuals and groups of people cannot enjoy rights and freedoms unless the community acts together. As Justice Churchman observed in the case of a former customs employee, that case addressed the intersection between legislation designed to achieve the public benefit of limiting the risk of the spread of COVID-19 virus and private interests in an employee relationship. In political theory, this tension between group interests and individual liberty interests is sometimes talked about in terms of claims different groups make to what are called public goods. Some public goods can only be enjoyed and obtained collectively. Now, taken too far, collective rights are used by communist, fascist, or theocratic regimes to suppress minorities and individual liberties. Conversely, extreme views of individual liberties trumping community rights beget unjust outcomes too. For now, the only way we can protect the public in the COVID environment without lengthy lockdowns curtailing many liberties is through high vaccination rates. It really is very hard to achieve community protection against COVID-19. And I believe that currently, unless an individual has a medical reason not to be vaccinated, which he knows is a very small group of people, there's a fair expectation that all who can should. On the purchase of the AstraZeneca vaccine, our purchase of the AstraZeneca vaccine should further reduce reasons for objection where those are based on concerns about the Pfizer jab. We have used public education and provided free services. The Fourth Estate, as distinct from the Wild West ravings on social media, the Fourth Estate has been an important and responsible critic and intermediary. On Super Saturday, 130,000 people got vaccinated with events across the country, and the atmosphere was one of joy and positivity. Community-based initiatives will continue to be important as we achieve ever higher vaccination rates. We've made it clear that those who choose not to be vaccinated will be able to access essential goods and services such as healthcare, food from supermarkets, and compulsory school education. But in order to protect all of us, and especially the most vulnerable in our community, unvaccinated people may not be able to enjoy some of the things that others can. This is not out of a desire to be punitive or out of a lack of tolerance for often genuinely held beliefs. Its purpose is to minimise the spread of COVID so as to protect others, although it will, of course, nudge some people towards vaccinating. Vaccination certificates will now become a feature of daily life as we move into the COVID-19 protection framework, also known as the traffic light system. Many businesses and event holders will be able to choose whether they use vaccine certificates for their customers. At each of the green, orange and red levels, using vaccine certificates will allow gatherings like weddings, hospitality and gyms to operate with fewer restrictions. COVID vaccine certificates reduce the risk of COVID spreading and consequently reduce serious illnesses, hospitalisations and death. Some private companies have announced that they will not serve or allow physical access to unvaccinated people from summer music festivals to international flights. Others are requiring their staff to be vaccinated for the protection of other staff or their customers. Private sector decisions do not trigger the same Bill of Rights Act balancing exercise that applies to government decisions. Human Rights Act obligations not to discriminate, say, on the grounds of disability may be engaged. It's unlikely that exclusion from music festivals or international flights or private premises would be unlawful. Not being able to go out to dinner is simply a consequence of their refusal to be vaccinated. For vaccine certificates to be equitable, all eligible sectors of the population should have access to the vaccine and have had a fair opportunity to consider whether they wish to be vaccinated. We believe that precondition is met. There needs to be, and is, a non-digital certificate option for those who don't have access to smartphones, and an exemption is needed for those who medically cannot be vaccinated, and of course solutions for children for whom the vaccine is not approved. We're satisfied that our vaccine certificate plan is fair across these grounds. They will also reassure the public that people around them at venues and gatherings are also vaccinated, and their risk of contracting and spreading COVID is significantly reduced, and all of this will reduce the burden on our healthcare system. Vaccine certificates, then, are a crucial part of the equation in reducing the reliance on lockdowns and to reconnect New Zealand with the world. Nevertheless, the message is clear. If you choose not to be vaccinated, there will be things you miss out on. To give as much clarity and certainty as possible to how vaccine certificates and other controls under the traffic light framework will work, the government has set out all of the controls for each of the traffic lights by including them in one new order now, but made only some of these controls active right now. This means that New Zealanders can see all of the controls that could apply at red, orange or green, or if a localised lockdown is needed. Turning to vaccine requirements for work. People who choose not to be vaccinated do not always have free choice of employment. The government has introduced vaccine requirements for those working in MIQ, border, health and disability, education, prison workforces, police and defence force personnel. Vaccine uptake by those workforces is now in the high 90%. Workers at businesses where customers will need to show COVID vaccine certificates, such as hospitality, close personal contact services, are also required to be vaccinated. The government's decisions around vaccines for these workforces have been based on robust risk assessments to minimise the spread of COVID, particularly to vulnerable populations. Beyond these areas, it's up to the PCBU, the person conducting a business or undertaking, a concept that is used in the Health and Safety at Work Act. We have responded to requests from the private sector to design a relatively simple protocol or tool for them to use, but it's not compulsory and other health and safety tests can be applied. Vaccine requirements established under the COVID-19 public health response vaccination orders have already been challenged in the High Court in 3 cases so far. GF and 4 aviation security employees about the border worker mandate, 4 midwives, NZDSOS Inc. and NZTSOS Inc. about the healthcare and teaching worker mandates. The Crown accepted in each of these cases that for employees, the choice of either being vaccinated or having their employment terminated engaged their right to refuse medical treatment. In all 3 cases, the rules were found intra vires the Minister's powers under the COVID-19 Public Health Response Act. In the border worker cases, the court found that the limit on the right to refuse medical treatment imposed by the vaccination for work rule was justified under Section 5 as it served a sufficiently important purpose and was proportionate to the risk of the spread of COVID-19. The Section 5 justification issue in the NZDSOS case about the healthcare and teaching workforce mandates will be set down for early 2022. More detailed provisions for vaccine requirements have now been shifted to primary legislation. This was a suggestion that was made by the courts, with orders detailing the types of work and additional detailed requirements. And as I said, responded to courts concerned about these measures being implemented via more general empowering provisions. In GF, Justice Churchman cited Wawrika and the Czech Republic, a recent decision of the European Court of Human Rights about compulsory childhood vaccinations, which found that it cannot be regarded as disproportionate for a state to require those for whom vaccination represents a remote risk to health to accept this universally practiced protective measure as a matter of legal duty and in the name of social solidarity. As we have learned more about the efficacy and effects of vaccines, the Bill of Rights Act analysis of vaccine rules becomes clearer. When we were unsure about whether pregnant women could be safely vaccinated, blanket mandates without exemptions risks discriminating against people on the basis of sex. Now that we know that pregnant women can, and indeed it's important that they are, be vaccinated, this issue becomes less difficult. No major religion has counselled its followers to refuse vaccination on theological grounds. The government believes people are fairly asked to bear the consequences of their choice not to vaccinate. There are a small number of people who, because of allergies or similar medical issues, cannot be vaccinated. Rules without exemptions for those people risk discriminating on the basis of disability. While we've learnt that this group is very small indeed, there are exemptions for those who, for a legitimate medical reason, cannot be vaccinated. Without measures like vaccine certificates and requirements for work, we would be, I emphasise again, reliant on more lockdowns and closed borders, curtailing many other freedoms. As Canadian academics Colleen Flood and Brian Thomas have recently said, the choice is between a world where everyone remains cycling in and out of lockdowns versus a world where lockdowns are limited to gatherings that risk disease spread. To prefer universal lockdowns is to pursue a perverse levelling down vision of equality. I could equally quote the US Supreme Court writing in 1905 in Jacobson and Massachusetts, a case about compulsory vaccination against smallpox. Individual rights cannot trump the common good. Otherwise, the court said, the spectacle would be presented of the welfare and safety of an entire population being subordinated to the notions of a single individual. The weighing of public goods against individual rights is complex, but we should not let the choices of a few hold back New Zealand's progress towards a safer and freer future. So last week, we passed under urgency the empowering legislation for the traffic light system and COVID vaccination certificates, or CVCs. This has sparked a lot of comment and some criticisms. In fact, I foresaw that in advance of arranging this for this particular timing. The empowering legislation that shifts CVCs sits within the COVID-19 Health Response Act, so protections applying to orders also apply to CVC orders. In the case of the courts and what they do, we have not imposed government vaccination requirements. People have to be able to access courtrooms. We're working through these issues with the judiciary. We want them to control the process in their own courts. We don't want there to be an implication that the executive is making these decisions. This is important to preserve the integrity of the justice system and to maintain public confidence, not just in the court system, but in the COVID response, because this includes the ability of the courts to scrutinise the action of the executives, free from accusations that they're somehow in league with the executive in respect of issues of access to the courts and vaccines. The traffic light regime and the role of CVCs was signalled in advance, so our approach was not a surprise. Furthermore, regulations, each order, will be reviewed by the Regulations Review Committee, so there is parliamentary scrutiny that's not always acknowledged by our critics. When the country faces a significant crisis, be it war, natural disaster, or in the current case a pandemic, the government does need to move quickly. When legislation is required at pace, urgency throughout the policy and lawmaking process can be essential in the public good. There is huge complexity under the hood, and in some ways legislation is the output when all of that complexity, the practicalities, complex policy issues have been resolved. The speed of lawmaking is determined by these practicalities and by society's need to urgently adopt new rules in substitution for existing lockdown restrictions. This involves political as well as legal judgments, which include maintaining the necessary social consensus which every day of a prolonged lockdown puts at risk. The future, as we all by now know, is uncertain. The emergence of Omicron, this latest COVID-19 variant in recent days, has sparked determined activity in the scientific and medical communities around the world as we seek advice and guidance. However, our strategy holds strong, and we have proven ourselves so far to be resilient to these unprecedented challenges. With ever higher vaccination rates, come more options and fewer restrictions. As this virus mutates and as science advances, we too will respond swiftly, supporting those affected. The new protection framework moves us beyond lengthy lockdowns and their significant economic consequences. Border restrictions will loosen, self-isolation will be the norm for lower-risk travellers. Carefully stepping through the transition from elimination to containment provides certainty of progress and the agility to respond quickly while maintaining our hard-won gains. Our calm and caring science-driven approach has resulted in more freedoms in New Zealand and less death hospitalisation, as we have previously said. And we've done all of this while honouring the Bill of Rights, protecting the rule of courts, the Parliament and the opposition. As the Prime Minister has often said, we don't claim perfection, but our record in responding to the unprecedented challenge thrust upon us by COVID-19 is, I believe, second to none. We have had to move quickly and into areas seldom seen in peacetime. It is remarkable, in my view, that we have redesigned so much and brought it together in time. As I said previously, Cabinet decisions are preceded by significant policy work. We have to design software. We have to redeploy staff, redesign test protocols, health protocols, consider how we're going to treat people into the community instead of in hospital or at MIQ. We've got to consider so many implementation practicalities. We've got to get expert advice. We've got to consult unions and employers, the Privacy Commissioner and others affected. So in terms of COVID, the apparently simple act of drafting and passing a bill is really the penultimate step, important though it is, in a very complex process. For most part, people have been with us and they've risen to the challenge despite the burden, despite the sacrifice and despite the hardship. So after 2 years of dealing with COVID-19, and boy, it's been a long 2 years, it remains a privilege to be an elected representative entrusted with these important decisions. I believe that if anyone or any country can come through this pandemic and look to the future with optimism, it is New Zealand. Tēnā koutou, tēnā koutou, tēnā koutou katoa.
Thank you, Mr. Attorney. We now have about 15 minutes for questions. So if you'd like to ask a question for those in the room, you can signal to me and catch my eye. I see there's someone coming through as well. Joel Colin-Rios will also keep an eye on any coming in virtually. I'll just collect up a few questions as we go. I wonder, Mr. Attorney, though, if I can take the liberty of the chair to press you on your vetting role as attorney, and it's not unsurprising that with the vaccination legislation that was passed, that the advice to you was that the legislation or the amendments were compliant, because we're talking about changes to empowering legislation which anticipates and demands that the secondary legislation is compliant and can't be inconsistent with the Bill of Rights. But I wonder whether that kicking the issues of rights down the road somewhat takes the heat out of the sail of the voice of Parliament. Shouldn't Parliament be informed more deeply on the important balancing and rights calculus through I say perhaps a richer vet of the legislation?
Oh, I think the Bill of Rights vet was pretty simple, actually. It was simple because the original COVID Response Act has all of the protections in respect of Bill of Rights issues that I've already elucidated on, and which have been so ably demonstrated by the court response to challenges against orders. So I didn't find it a difficult Bill of Rights vet at all. You can make things longer than they need be. It's a relatively short vet because the issues, I think, are simply described.
Thank you. I've got a question over here, and when you ask your question, just if you're comfortable, just please identify yourself.
Thanks so much for that. One of the things you emphasise early in the speech was the value of giving responsibility to scrutiny of New Zealand's legal response. That can be something to be established now. Is the return of that committee something which the government would contemplate to improve?
Can I just jump in? I'm not sure the audio came through there, but there's a question about the Epidemic Response Committee and whether it's being recontemplated.
Yeah, no. It was a necessary response to when we didn't have Parliament sitting. Parliament sits again, has sat since. If Parliament was no longer sitting, we'd obviously have to address that question again. But select committees are sitting, question time's operating. None of those things were operating at the time of that select committee, so we don't think that that's a necessary adjunct to the normal parliamentary processes now that we're back to relative normal.
So I've got questions just behind. We'll go first behind and then we'll come to the Knights of the... Thank you.
Kia ora, Mr Parker. My name's Susanna. I'm a student here at the law school. This question is in relation to your mention of the repealing of the 3 strikes regime. And from my understanding, the UN Human Rights Committee has determined that New Zealand's refusal to pay compensation for those wrongfully detained by judicial act breaches the ICCPR, which directly contradicts New Zealand's Supreme Court judgment and Attorney General in Chapman. I'm just wondering, in regards to the no compensation clause in that bill, whether the government would look to change that in response to this ruling. I won't express a strong opinion on that. Suffice it to say that we're remedying the underlying ill here, which is further injustices caused by the prolonging of that legislation. We think that's the most important aspect of this.
I think we can come down to Sir Geoffrey.
Thank you, Mr Attorney, for that address. It was very illuminating. I think that probably never in the history of New Zealand has so much law been made so quickly to deal with such a serious situation. And in some respects, the restrictions are greater than those imposed in wartime here. And it's been a terrific challenge to the New Zealand government, and the New Zealand government has demonstrated that it works. I only have one question. In 2020, you passed the legislation that you mentioned, and then you, after the election, you revised it, you went through a select committee procedure and you amended it. When you used urgency last week, there was no scrutiny, and you did not give an undertaking to examine it again in the way you had the year before. And I would really like to know what the reasons were that there was no select committee scrutiny or no opportunity for that.
In respect of your first point, actually, one of your learned colleagues in the law did raise with me the pale comparison of the legislative overrides that we've had here compared with those of the Fraser government in World War II, which were far more wide-ranging and more draconian, actually. So although this has been an urgent response, I suspect we've learnt through, well, I suppose society's a bit more sophisticated in some ways about dealing with the detail of these issues than used to be in bygone years. So I would say that our actions have been moderate compared with the exercise of wartime powers. In respect of your question about select committee, we didn't have a select committee in the first and more important act. We did respond in the Committee of the Whole, which I was responding on behalf of the government in that, to opposition requests, including bringing orders to Parliament for their scrutiny. So we adopted that, and we responded to legal academics in respect of the idea of an inquiry on that occasion. But I've heard criticisms that we should have done the same on this bill, and indeed the Speaker of the House made the point that any of those select committees could have called for an inquiry of their own, including the Regs Review Committee, which is chaired by the opposition, and none of them did. So they've got the ability to put that motion, and none of them have. Maybe it's because there is an understanding in the House that the protections that we have in the first Act are the overlay that applies to all of these subsidiary provisions that have been put into it. And so any of the CVC orders or other vaccine rules are subject to the protections that are embedded in the Act.
Can I perhaps follow up just a question on those protections? Because we're fast approaching summer and Parliament's going to be downing tools, and many of those protections are parliamentary. And I think, for example, the confirmation time limit for the orders, I think, according to my math, doesn't need to happen until February 16th, 15th or 16th in terms of the 10 sitting days. And Regs Review obviously has other processes as well that they may engage. But have you anticipated, or what's your expectation about how those protections may play out when a lot of Wellington is downing tools and on holiday? Does that deflate any of those protections, or how do you anticipate they might be used while Parliament is in recess?
Well, just about like any legal deadline, there is a slightly longer period over the summer break when people aren't at work. And if you don't have those longer periods, those protections don't really work that well. I do have a sense that people outside of Auckland do not realise how frayed the social consensus around current mechanisms of control of the virus has been. It's been very hard for people to be in a lockdown for 100 days. And, you know, it might be unfortunate, but it's as true now as it was when we produced the legislation last year, which was also at a pivot point. You've got to be able to pivot to maintain a social consensus. And for me and for the government of which I am part, we were persuaded that urgency was necessary and that the protections in the current Act are sufficient, and that if we didn't and we were reliant on lockdowns, those lockdowns would stop working because fewer and fewer people would adhere to the rules, and without substitute rules, COVID would spread and people would die.
Thank you. I think we have a question in the middle.
Kia ora. Thank you for today's presentation, Kent Newman from Vic. Your role famously involves this balance between your political function and your constitutional function as the Chief Law Officer. And as you mentioned, you've taken on this other hat of also being quite involved in the policy. How do you see that balancing occurring under times of crisis, particularly when you're taking on these new roles? Do you believe that constitutional role equation modifies at all, or is it just business as usual?
I think times of crisis heighten the importance of these issues. I'm actually really pleased that I was asked to have a role in that COVID Act. I reckon if Sir Geoffrey had been around at the time and he wasn't Minister of Justice, through which he could have done it because he used to carry the role of Minister of Justice as well as Attorney General, he'd have been pushing the door open and saying, let me in so that I can make sure that unbridled power does not occur and we protect the rights of the individual under the Bill of Rights Act. And that's what we've done. And that's what I've had a hand in doing. And, I often get the same question in respect of environmental roles that I've had. People say, look, I was at one stage Minister of Economic Development and Trade whilst also being Minister for the Environment, and people would say, surely there's a conflict between the two. And back in the day, that might have been the case. But now, in environmental policy, I think people that hold development portfolios try to do it in an environmentally responsible way. At a time of crisis like this, the intersection between the political and the principled becomes very important. And I think the people who have an understanding and a desire to protect those civil liberties, it's really important that they get involved. So I think it's turned out all right.
Thank you. I just got a question to my left over here.
Kia ora, ko Anira Wāinga tōku ingoa Hurio no Te Whānau Punui Tainui me Ngāpuhi. I am the current tūmaki for next year for the Māori Law Student Society. So there are a lot of students, well not a lot, but there are some that are immunocompromised, and obviously with the mandates and with the vaccinations, a lot of us are losing either positions or jobs. And I understand that the government, some ministries, have also made it a requirement to be vaccinated even though you have a medical exemption. So are there going to be more like protection or frameworks around those that are obviously going to be affected by vaccinations?
Some so-called medical exemptions are bogus, others are not. Those that are not bogus should be honoured. So, yeah. Well, I said not all medical exemptions or so-called medical exemptions are accepted. Those that are legitimate, and there is a route to test them, are honoured. Those that are bogus are not.
Joel, questions, virtual questions?
Yes, we do have more than 10 questions from the online participants, but I will just limit, I'll just ask two. The first one is from Fiona MacDonald. Can the attorney comment on how the framework for COVID responses engages with treaty rights? And
what engages what rights?
With treaty, the treaty rights, Treaty of Waitangi rights.
Oh, treaty rights, yeah. Right.
And second, we do have a question from Hannah Wilberg. Could you perhaps give some indication of why the amendment to the COVID-19 Response Act did not include express mention of vaccines? And if I can just ask very quickly a third one here from Andrew Ecclestone. So the trade-off of public goods against the infringement on people's rights to movement and association that the vaccination pass represents rests on the vaccination pass regime being upheld. But because the government has now said venues can choose to only view a pass rather than verify it, the public good is less likely to be secured. How does this affect the trade-off against the rights infringement?
So I think the three questions, the first one was about the titility.
Yes.
The second one was about the absence of the words vaccination in the empowering provision on the entry to businesses clause, and the third one was the validation of the certificates, why that was dropped, if I can paraphrase. I'll let you deal with it.
I'll deal with the treaty rights one. Government duties under the principles of the treaty include the duty of protection. We have endeavoured to ensure that all parts of the New Zealand population, including Maori, are able to be vaccinated and are vaccinated. There has been some criticism of us in that regard. The vaccination rates, we chose to vaccinate by age cohort because that was the best proxy for risk, overlain with criteria that also went to comorbidities. And under those, and we also, because of the risks arising out of close population densities in South Auckland and the prevalence of comorbidities in that area, we also prioritise that area. So we have been trying to ensure high rates of vaccination, including amongst Maoridom. In respect of older Maori, who were the first in the first cohorts that were eligible for vaccination rates have been very good. In respect of overall averages, those averages are somewhat distorted by the different population curve of Maoridom compared with the rest of the population because they're a younger population cohort on average. That said, we also have pivoted to try and use any method that we can, including Maori service delivery partners, in order to try and reach Maori to obtain ever higher rates of vaccination so that they achieve the same levels of protection that are already present in some other cohorts of the population. Some of that has been litigated. The Waiparere Trust took the government or the Ministry of Health to court on their refusal to provide all of the data that they wanted. In response to that, the ministry provided some additional information to the Waiparere Trust. The lack of provision of the other information that they wanted at the granularity that they wanted is subject to another court process, and the courts will deal with that. I don't know that I can add much to that. There isn't a treaty clause in the COVID response legislation bill, but it doesn't need one for the Crown to recognise its obligation to all New Zealanders. In respect of the other issues, just remind me.
It's the empowering clause that allows the operation of the vaccination certificates for people going in and out, the absence of the mention of vaccination and that, and I think it's clause off the top of my head, 12(2)(b), A Roman 1. It just seemed a bit odd.
Oh, look, I'm happy to look at that, but I'm confident that the empowering provisions work.
And there was one about the scanning, and we may not have time. You're welcome to take that if you wish.
What about scanning?
About the decision not to insist on the validation through the scanning app that was built.
Again, I would have to look into the papers as to why the final policy decision was made in respect of that particular detail. I don't know off the top of my head.
Thank you. Well, our time has come to an end, but we have been benefited, I think, from some real insights into some of the constitutional implications of our government's fight against the virus, reflections on the rights calculus and some of the protections built into the system. The dialogue has been rich and I think represents an important contribution to accountability of government in the time of emergency. The only thing I've got left to do is ask you to join with me in thanking David Parker, the Attorney General, for giving his time to address the